This question is regarding revocable joint trusts and if one spouse can change the trust after the death of the first spouse to pass and tinker with the beneficiaries. And the answer, as all legal answer is, it depends. And in the trust world, it depends on how it was written and what the rules are. So generally speaking, if you truly have a joint trust where both spouses are the grantors or the people creating the trust, both spouses are the co-trustees or the people managing trust assets, and both spouses are beneficiaries, meaning they're entitled to benefit from the trust assets, then without special language on the first spouse to pass, the surviving spouse still is a grantor, trustee, and beneficiary of a revocable and amendable trust, and they can amend the trust however they see fit. And many times when we have a nuclear family where the children are all from the current marriage, then that doesn't really matter, or at least it's not important to the spouses. Certainly when we have blended families, there's probably always the idea in the back of at least one spouse's mind of like, well, if I die first and then my surviving husband or wife decides to cut out my kids and leave everything to theirs, like I won't be around to complain about it. So when we have those situations, we have a few different options. One of the options is we can put a special provision in the joint revocable trust that says upon the first spouse passing, the trust shall become irrevocable with respect to the beneficiary. So we lock the beneficiaries in place upon either spouse passing away first. So that works. There's probably some loopholes of a good lawyer that could get around that, but generally speaking, it keeps honest people honest. The other option that is probably safer is to have two separate trusts, a husband's trust and a wife trust, or two husbands or two wives, as to not be yelled at for being insensitive. But I digress. So the idea is that if we have both spouses have their own trust, then they can do anything they want, and you can leave stuff upon your passing partially to your spouse and then partially to your child or children from premarital or whatever you have. And that way, nobody gets into your trust. It automatically locks down at the time of your death, and your wishes will be carried out. And so that works well for everything except for joint assets, which we'll talk about in another video. So, hope you guys have a great day.